Hello everyone, greetings of the day. Hope you all remember me. Yes, this is Komal Mathur, a legal intern at LEXIS and Company and a law student at Manipal University, Jaipur. So today we are going to discuss about LGBT rights in India. So let us start with a brief introduction. In India, lesbian, gay, bisexual and transgender, collectively known as LGBT, rights have progressed dramatically in recent years. However, Indian LGBT residents continue to suffer societal and legal challenges that non-LGBT citizens do not face. The government has removed a colonial area regulation that discriminated against homosexual and transgender identities, as well as specifically interpreting Article 15 of the Constitution to outlaw discrimination based on sexual orientation and gender identity. However, numerous legal rights such as same-sex marriage have been still left out. Under legislation implemented in 2019, transgender people in India can change their legal gender after undergoing sex reassignment surgery and have the constitutional right to register as third gender. Furthermore, several states provide accommodation for hijras, a traditional third gender population in South Asia, as well as welfare benefits, pension systems, free operation in governmental hospitals, and other programs specifically aimed at assisting them. In India, there are about 480,000 transgender persons at present. The Supreme Court of India decriminalized consensual gay intercourse in the landmark case of Navdeep Singh Johar versus Union of India in 2018. By reading down section 377 of Indian Penal Code and eliminating consenting homosexual sex between adults from its scope. Now, let us know something about the history of this whole LGBT thing and how it became criminalized and how it got decriminalized. So let us first start about the things given in Hindu scriptures. According to various accounts of Mahabharata, certain characters such as Shikhandi, who is sometimes claimed to be born as a female but identifies as male and subsequently marries a woman, change genders. Bahuchara Mata is a goddess of fertility who is patroness of hijras according to Hindu scriptures. The Narad Smriti and Sushruta Samhita, two classic Sanskrit works on dharma and medicine, proclaim homosexuality immutable and prohibit homosexuals from marrying a partner of other sex. The Kama Sutra, a Sanskrit literature on human sexual conduct, employs the term Tritiya Prakriti to describe individuals with homosexual urges and their activities in considerable detail. Lesbians, as written in Hindu scriptures, Swarini, who was indulged into forceful lovemaking with other women, bisexuals, referred to as Kami or Paksha, transgender and intersex people are all described in Kama Sutra. However, there are many punishments for homosexuality in other Hindu literature, like the Manusmriti. Girls who had sex with the other girls were fined 200 coins and given 10 whippings. A mature woman who had sex with a girl was punished by having her head shaved and having 2 of her fingers amputed, as well as being forced to ride a donkey. In the case of homosexual men, the Manusmriti stipulated that a sexual union between two men resulted in caste laws. Now, what about pre-Islamic rule? Now, during the pre-Islamic time, several portrayals of homosexual activities may be found in the Hindu Khajuraho temples, which were known for their erotic sculptures. Maybe you all have also visited some kind of these old temples and have yourself witnessed these kind of erotic sculptures. Historians have long contended that pre-colonial Indian society never criminalized or nor viewed same-sex relationships as evil or bad. Though some text contains injunctions against homosexuality, particularly among priests, and Hinduism has always viewed homosexuality as natural and joyous. But according to Al-Biruni, Hindus are strongly opposed to homosexuality. Now, what about the post-independence period? Section 377 and other legal prohibitions against private, adult, consenting and non-commercial same-sex activities were ruled to be direct in violation of Indian Constitution by Delhi High Court in NAS Foundation versus Government of NCT of Delhi in 2009. However, voluntarily has carnal intercourse against the order of nature with any man, women and any animal shall be punished with life imprisonment or with the imprisonment of either description for a term which may extend to 10 years or shall also be liable to fine. According to section 377 with a caveat that penetration is sufficient to constitute carnal intercourse necessary. Decisions of a High Court on the legality of a statute according to the prior order by the Indian Supreme Court apply throughout India, not simply to the state over which the High Court has authority. There have been instances of authorities harassing LGBT groups in violation of the law. Then on 6 September 2018, the Supreme Court issued its verdict. The court unanimously ruled that the Section 377 is unconstitutional as it infringed on the fundamental rights of autonomy, intimacy, and identity, thus legalizing homosexuality in India. The court explicitly overturned its 2013 judgment. Criminalizing carnal intercourse is irrational, arbitrary, and manifestly unconstitutional, said by Chief Justice Deepak Mishra. Justice Indu Malhotra says that history owes an apology to these people and their families. Homosexuality is a part of human sexuality, and they have the right to dignity and free of discrimination. Consensual sexual acts of adults are allowed for the LGBT community. Justice Dhananjay Y. Chandrachud says that it is difficult to right a wrong by history, but we can set the course for the future. This case involves much more than decriminalizing homosexuality. It is about people wanting to live with dignity. Furthermore, it ruled that discrimination, any kind of discrimination on the basis of sexual orientation, is a violation of Indian Constitution. Sexual orientation is one of the many biological phenomena which is natural and inherent as an individual and is controlled by neurological and biological factors. The science of sexuality has theorized that an individual exerts little or no control over who he or she is get attracted to. Any discrimination on the basis of one's sexual orientation would entail a violation of the fundamental rights of freedom of expression. Supreme Court also directed the government to take all the measures to properly broadcast the fact that homosexuality is not a criminal offense and to create public awareness and eliminate the stigma of the LGBT community, stigma that the members of the LGBT community face, and to give the police force periodic training to sensitize with them about this issue. So that's it for today. Thank you everyone. Have a nice day.